right. Hello, everybody. What's going on, chat? I know it's been a couple of days since I've streamed, but today we have a special stream. We're going to be going over the rules and responsibilities of lawyers and what it takes ethically to be a lawyer. So let me just pull up chat here over on the side and make sure everything's working, and we'll be set to go. Okay, yeah, that looks like it's working, so all right. Now, most of you probably know what the bar is, or you've heard of the bar, but to become a lawyer, there's actually a couple of different things that you need to do. You need to, one, go to law school and graduate. Two, take the bar in the state where you want to practice and pass, and the bar is a very, very difficult test for those of you who aren't aware. And then three, you need to pass character and fitness, which means that the legal entity, the bar, will go and dive into your entire history to make sure that you haven't committed any serious crimes, any crimes that you did commit, whether or not they're serious, that you've kind of rehabilitated, you're doing okay, you know what you did wrong, and you're remorseful, and to make sure that you're just a good qualified person in general to enter the legal field. This is a very strenuous process. A lot of people really struggle to get through it, and there are plenty of people who went through law school, passed the bar exam, and then couldn't pass character and fitness. In addition to just passing the character and fitness exam, though, you also need to pass the MPRE, which is just a professional responsibility exam. Right now at ASU, they have 1L law students take a PR class, a professional responsibility class, so that way they're prepared to take the MPRE, and so that way we can get certified to start working in the legal field right away, because there are a couple of prerequisites to get, I believe it's called Rule 39 certified, where you're allowed to actually go into court. Those prerequisites are your 1L classes, professional responsibility, and evidence. I think that the three classes you specifically need are civil procedure, evidence, and professional responsibility. Professional responsibility is typically taught at most universities as a 2L or even a 3L. Here at ASU, they make us do it as a 1L. And for those of you who don't know what professional responsibility is for law students and for lawyers, it's a set of rules that you have to follow. Otherwise, you can get kicked out of the bar and you can be forced to stop practicing law. And these aren't rules on how cases should be decided like you'd think. These are rules on how you have to act. There are things such as don't accept bribes, don't have sex with your clients, you need to be respectable in public. So if you're a lawyer or a judge, you can't be part of racially discriminatory groups. You can't do things that make the profession look bad. And this is because we're a self-regulating profession. We don't have a government agency that's deciding who gets to be lawyers. It's lawyers who decide who get to be lawyers. So in order to be a lawyer, again, you need to graduate from law school, take and pass the bar, and pass character and fitness, which also means taking and passing the MPRE in most circumstances. With that in mind, today we are going to go over a ton of different practice questions, because my exam is tomorrow morning and it is open notes and open book, but no internet access, which is kind of weird because the rules that we follow are online. We follow the ABA model rules, so the American Bar Association's rules on ethics, but we don't have physical access to that, so we need to like type up the rules and have them there for ourselves on the side. But we'll see how I do. It's going to end up being like just a ton of multiple choice questions, and it's just testing how good you are at ethics, basically. So I have a bunch of the questions from the book. We're actually just going to go through the questions from the book and try and figure stuff out from there. So if anybody has questions on why an answer is the way that it is, let me know. Or if people want to just take their shots at answering the questions as we go through, they're all multiple choice, and I'll pull up the rules that apply to them as need be. But let's get straight into the book, because I am running a bit later today than I had anticipated. Wrong one. Okay, here we go. I'm running a bit later today than anticipated. I wanted to have this going like at noon, but I had to run and get some groceries. This guy, his car broke down in the Walmart parking lot, so I had to try and help him out a little bit. But okay, so these are the questions we're going to be going through. I also have an answer key for these, and I have a couple of different outlines. And then I have a set of the rules like condensed over here, and we'll pull up the actual rules if we can't get through the questions without pulling them up. So we're just going to go through these. We'll stop after every like 2 or 3. So if you want to work along with me, grab a piece of paper, write down your guesses, write down your answers, and we'll go through them together. So let me flip to a clean page. Okay. Everybody got their writing utensil and stuff ready? Oh, that is busted. I don't even have mine ready. Okay. So the first question up here isn't important. It's just asking, identify a website where you can find everything that you need for bar admission or to become a lawyer. Just type into Google bar admission requirements for X jurisdiction, and jurisdiction is just the state or principality that you want to work in, depending on like what part of the country you're in. So these are the actual questions. Legal definition of professional responsibility. I'm going to, instead of doing question 1-2, I'm just going to do question 1. So the ABA model rules for professional conduct are, and feel free to take your guess at these as we go, binding on all attorneys in the jurisdiction, models which jurisdictions can accept, reject, or modify, binding only on members of the ABA, and the only legal standard governing lawyer conduct. You know what? I think instead of me reading all of these out, I'll read the question, let you guys read through the answers, and then we'll go through it afterwards. So let's do these first 3 here. Okay. In the United States, the predominant, although not exclusive, authority for lawyer regulation is... And then this third question. Which, if any, of the following sources of authority is not binding on lawyers? All right, I'll give y'all a second to write in your answers for these 3, and then we'll pull up the list of answers. California has its own professional responsibility for answer 1. Actually, this relates to the correct answer for this first question. Every state has their own set of professional responsibility rules. So the correct answer for this is B. The ABA model rules. Model is the key word in that circumstance. They aren't binding on any attorneys. They're just recommendations of what the professional rules and professional conduct should be. So A is incorrect. They're models which jurisdictions can accept, reject, or modify. So this is the correct answer. Jurisdictions can do whatever they want with the model rules. Arizona, where I'm going to law school basically just copy and paste them over with very slight modification, but they could have done whatever they wanted with them. C is also incorrect because they aren't binding in general. And then D, also incorrect. They are not legal standards that would govern lawyers' conduct. They're just models that you can do whatever you want with. It's the same thing as the model penal code. For those of you who were here when I was studying for criminal law, the model penal code is a list of just model rules that should be followed. You can take it and do whatever you want with it. You can adjust it to your state's needs. Okay. Question 2. The predominant, although not exclusive authority for lawyer regulation is, and this is C, the judiciary. Okay. It's not the legislator. Although lawyers are subject to legislation, the legislation is not the predominant source of regulating lawyers, except in California, where both the legislature and the judiciary regulate lawyers. So, Gemma, in California, these answers wouldn't be correct for this because there the legislature and the judiciary split the duties, kind of. Executive branch doesn't have authority over lawyers. They generally just don't regulate them. But the judiciary is typically responsible for regulating lawyers, admitting them to the bar. The State Bar Association is a branch or a subset of the judiciary, so that's why that's incorrect. I know that you know, I'm just explaining it so that I'm just saying it that way if anybody's rewatching the VOD, they can pick up on that little bit of nuance. Alright, and then the third one that we answered, which, if any of the following sources of authority is not binding on lawyers? So, this just relates to typical legal methodology. What's binding is prior case law and actual laws that go into effect, and in this case we have case law on malpractice, criminal law, and Sarbanes-Oxley. So 2 actual sets of real law, and then 1 set of case law. And those are all binding, and lawyers need to abide by those rules and regulations. A restatement isn't binding. It's just persuasive authority. So think back to your legal method classes or your very first legal writing classes. You think of the difference between binding and persuasive authority. All right. If people have questions on any of those answers, feel free to drop them down. But if not, we will be moving on to the next couple of questions. Okay, so there's what? 5, 6 of them here. We'll go through these. I'll leave a little bit of time for each of them. We're going to skip over this one right here because it's just a short answer, and I'm not doing any short answer questions on my exam. It's all multiple choice. No, I have a... Okay. So, question 1-6, which is our question 4. All of the following are traditional elements of professionalism except... Okay. The dichotomy between a business and a profession. You know what? Instead of doing it this way, I'm just going to basically answer these, review the answers, and we'll see how things work out from there. I left this till the very last minute because this class was very off the rails, and it's not really something that you can study and prepare super hard for. So I'm just kind of winging it with this, even though the final's in the morning. So we'll see. In fact, let me pull that up. There we go. That way if people pop in, they'll see that I'm just answering the questions, and if they have questions, they can drop them in the chat. Okay, so all of the following are traditional elements of professionalism except representing clients as zealously as possible within the bounds of the law. This was actually removed from Arizona's most recent set of rules because lawyers were using this as an excuse to just be assholes to each other. So being zealous is a little bit too far, and most jurisdictions have actually pulled back on that requirement. You know what? This might not be the best way to prepare for this. I think it might be better to just pull up the model rules and go through those and explain those. So here, let me remove that. We'll go here. Okay, this is just a condensed version of the rules that I have. We'll go through this and the actual ABA model rules. I don't think that these multiple choice questions straight from the book will be super beneficial, just because a lot of them are opinion based, and yeah. So let's go ABA model rules. Okay, so this is the ABA, or American Bar Association website, and on it we have a list of all of the model rules. This is what most jurisdictions use as their baseline to come up with their own rules of professional responsibility and professional conduct, and they're broken down into these different categories. The first one is the client and lawyer relationship. Next up is your roles as a counselor, then your role as an advocate, how you interact with other people besides your client, and then what firms do, what you are allowed to do as a public service, and then there are a couple of other things down here that aren't as important to the straight up lawyer professional responsibility stuff, but they're more so for the actual admission into the bar. So let's get started up here with the one that everybody has heard of and everybody knows about, and that's competence. In order to be a lawyer, you need to be able to provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So, in order to meet this class, before we actually break these down, let's talk about what these rules are. All of these rules are things that you need to abide by as a lawyer, and if you violate any of them, you'll receive a bar charge, which means that you violated a rule and the bar of your jurisdiction is going to investigate that violation to see whether or not you actually violated it, how serious the violation was, and what punishment they deem necessary. There are different grades of punishments for model rule violations or for professional responsibility rule violations. In Arizona, we call them the ethical rules. So the Arizona ethical rules, when you violate those, there are different grades to what you're able to receive as punishment. One is it gets dismissed. You don't receive anything. Second is a slap on the wrist that doesn't really go into your file. Like, it goes into your private file and it's removed after a couple of years. Next up is one that goes permanently into your file, just then admonishing your work and what you did. Next up, we have a public statement about what happened. There's this phrase among Arizona lawyers that you don't want to end up in the back of the magazine. That's because every month the Arizona bar will publish a magazine, and the last couple of pages have people's pictures. Yes, I'll actually get to that. That license revoking is a result of receiving a bar charge later on. So, back to the public announcement. If you get a bar charge and they find you guilty of it, they can give you a public admonition, which means that your name ends up in the back of the magazine, and on the website they put your picture and your info, and then they say what you violated, and oftentimes this comes along with a suspension. On top of that, the next level would be just straight up suspension for any period of time, and oftentimes, depending on the type of charge that you commit or the type of rule that you violate, you can end up being forced to go into counseling if you want to retain your license. And then the highest level is that your license is revoked. This is if you violate a serious ethical rule or model rule and the bar charge against you is severe. They find you guilty of it, they can revoke your license and you won't be allowed to practice law anymore. This typically only happens for really serious stuff, such as stealing from clients is a very big no-no. When you commit actual crimes. Yeah, and I was mentioning that it's something that happens in Arizona. I don't know about other jurisdictions. They probably do have it on the California Bar website if you want to take a look. I don't know if they actually have a magazine, but here in Arizona they print a magazine every month, and the back few pages are just pictures of lawyers who had bar charges against them and were punished. So that's what happens when you violate one of these rules. A bar charge is filed against you, and there's basically a little mini trial that the bar puts on where they try and figure out whether or not you're actually guilty and what you're guilty of. Nope, they don't have that in California? Okay. Well, my professors mention it quite a few times here for Arizona, so yes, that's only a thing here, but there are public The bar, depending on your jurisdiction, has different grades of what they can give you. The ones I just broke down are the ones that we have here in Arizona, and those are only if you're found guilty of the bar charge that you're charged with. And you will only get charged with those if you violate one of these model rules or ethical rules. Somebody actually has to file one against you, and then the bar will do its own investigation and trial. This is separate from and in addition to any criminal charges. So say you are, say you're stealing money from your clients, you can get a criminal charge and be charged as a criminal, and then you can get a bar charge on top of that where the bar will come after you for violating one of these rules. And that's just this list of rules. All of these are things that you need to abide by as a lawyer if you don't want to receive a bar charge and go through everybody looking into your personal history and what you did. And the first rule, and arguably the most important, is competence. So we're finally back to actually explaining the individual rules and not just them overall. So a lawyer shall provide a competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So, if you go and try and represent a client and you don't know that field of law, you can be said to be in violation of ABA Model Rule 1.1. So if you don't know about a certain area of law, you shouldn't be practicing it. So say you're typically a trust and estates lawyer, you shouldn't be going around working on commercial litigation unless you do research in it and put yourself up to that level. Attorney malpractice is a major claim. Yeah, malpractice is different from bar charges. Malpractice is something that a client will sue you for. The bar doesn't issue a bar charge for malpractice. They'll issue you a charge for violating one of the model rules or the ethical rules in your jurisdiction. A malpractice claim comes from a client who doesn't feel like you adequately represented them or that you did something wrong, and that's a civil charge that will go to an actual court. A ABA rule violation will be handled by the bar. Typically, if you get a malpractice claim, you are also going to get a bar charge against you, and they are very serious. Most lawyers actually carry malpractice insurance for this very reason, because clients tend to sue lawyers very frequently. So lawyers will pay an insurance company to cover them if they end up getting sued by their clients. I'm not sure what those question marks are at, but let me know what you're curious about, and I'll try and explain it. But back to Rule 1.1, you just need to be a competent lawyer, basically. If you aren't thorough, you just roll into court with a hangover, or you don't know about that type of law, you can be charged with a Rule 1.1 violation because you're incompetent. Okay. So now that you've seen Rule 1.1 and seen competence, now you kind of know a little bit about how these rules are going to work. They're rules that you just need to abide by so you don't end up getting charged by the bar, and they are basically logic puzzles. So real quick, just back to this, you need to make sure that you meet all 3 or 4 of these standards. Okay, it can be a claim in a bar association in addition to a civil claim. Okay, I wasn't aware of that. I was pretty sure that bar charges were typically associated to the ethical rules or the professional responsibility rules, not to malpractice. There are some rules that will cover malpractice, so if you violate those, you're already getting a bar charge. I didn't think that the bar itself actually brought malpractice claims against individuals. I'm fairly certain that that's not the case. I don't think that the bar actually brings malpractice claims. I think that they bring a professional responsibility rule violation related to that malpractice claim. But you said that it could be depending on the jurisdiction, so that just doesn't make a lot of sense to me why they'd do that, but it could be the case. Alright, let's move on to the next rule. The scope of the representation and the allocation of the authority. This is talking about what the relationship between the lawyer and the client should be and who should be doing what. So, a lawyer shall abide by a client's decisions concerning the objectives of representation and as required by Rule 1.4. All of these rules are interconnected. They all relate to each other. Shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. A lawyer shall abide by a client's decision whether to settle a matter. In a criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as to a plea to be entered, whether to waive jury trial, and whether the client will testify. This is a lot of legalese. That's all of these ABA rules are, is just legal jargon that you kind of need to parse through. So the big thing to get out of this is you as a lawyer need to be doing what the client wishes in terms of the objective of the representation. It is their job to decide what you should be suing on, when they want to settle, when they want to enter a plea agreement. That's what their job is. Your job is to just get to that outcome as best you can. And then there are just some caveats here. You representing a client doesn't mean that you're endorsing the client's views on anything. A lawyer may limit the scope of representation if the limitation is reasonable under the circumstances and the client gives informed consent. So you can modify this rule, and you can be in charge of, say, deciding when a settlement should be reached, so long as it's reasonable and the client has informed consent. Informed consent is typically defined under the ABA model rules as them being informed of the option, being told that they could or should seek outside counsel if they don't trust what you're saying, and then deciding based on that. Then D, a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. So basically, you can't tell your client to go around committing crimes or to destroy evidence. You can discuss the potential legal consequences of that. So say your client comes to you and says, hey, I'm thinking of shredding all of the documents at my office. I'm under investigation from the SEC. I don't know what we have in those documents, but I think I'm going to shred them. Would there be any legal ramifications? And you can tell them, yes, you might be charged with destruction of evidence if there's anything linking the documents that you destroyed to the investigation. So even if it's just a small thing, you could end up being charged with this additional criminal charge. And you can't tell them to do something criminal or fraudulent. You can just give them advice on what the outcome might be if they happen to do something like that. So, to break Rule 1-2 down, it's the lawyer's job to be as good of a representation as they can for their client, but it's the client's job to decide what the representation should be about, i.e. what they're suing for, how much money they want to go after, when they should settle, when they want to enter a plea bargain, when they want to waive a jury. Any of that stuff is the client's decision. How it's achieved is the lawyer's decision, and there are some limitations on what you can do. You can't counsel your client to break the law or do something fraudulent, you can just give them info on what might happen if they do, and you can modify this a little bit so long as they give informed consent. Next up, Rule 1.3, diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. This is something that some bigger law firms and bigger companies tend to get in a little bit of trouble with. What is reasonable diligence and promptness? Does this mean responding to emails right away? Responding to text messages on the weekend from your client? It kind of does. If you're a lawyer, you need to be able to respond promptly when you're representing a client. You don't get weekends off, really. If your client has questions on the weekend and it's something that they want the answer to right away, you need to give it to them right away, unless you set aside like rules at the start of the representation that, hey, you can only contact me these hours unless it's an absolute emergency. But yeah, this is something that a lot of lawyers get into trouble with, where they leave a client on red or don't answer their email for a day or two, and they can get in trouble for it. A lot of these rules are very restrictive, and they limit what you as a lawyer are able to do. You might not be able to use the means that you'd like, and you might be a little bit more just restricted than you may think. Okay, Rule 1.4, communications. Okay, so a lawyer shall promptly inform the client of any decision or circumstances with respect to which the client's informed consent as defined, blah, 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 is required by those rules. So if something comes across your desk that you need to tell the client about, such as if a settlement offer is given to you, you need to promptly inform the client. A lawyer shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. This relates back to Rule 1.2. A lawyer shall keep the client reasonably informed about the status of the matter. Basically just keep up with the client, promptly comply with a reasonable request for information. Keep up with the client, keep up with opposing counsel, don't leave things on read, don't just not answer emails. You need to be actually doing stuff and be on the ball. A lawyer shall consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules. So you need to let them know when what they asked you for isn't permissible under the model rules. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions. You need to actually explain things. So basically this rule is saying be prompt, respond to stuff, don't leave stuff on read, and you actually need to thoroughly explain things to the point that they'd be able to make the decision that is necessary for them. So that's what we have. That's our rules on communication. Rule 1.5. This is just about the structure of fees. This basically boils down to your fees and your costs to your client need to be reasonable. You can't just charge them out the ass for no reason. So let's pull over to here. This is probably the better way to break it down. So fees. Do not collect unreasonable fees. The things that go into deciding whether or not a fee is reasonable are time, labor, the novelty of the legal issue, the difficulty, how much skill it requires to answer it. So if it's a difficult legal question or something that the court hasn't seen before, you can charge more because it's something that's going to require more work. You can charge more if it's likely going to restrict you from getting other jobs. So long as the fee is customary, it's along lines that are traditional, like you aren't charging somebody for something that nobody else charges for. Uh, the amount of effort that you put in, the results that you get out, if it's a short time window, uh, the nature, length, and professional relationship with the client. You can charge certain clients more or less depending on how often you've worked with them. You can charge based on your experience, reputation, and ability as a lawyer, and you can do fixed fees or contingent fees. There are certain places where you can't do contingent fees, like you can't use contingent fees in criminal law cases. So, yeah, that one should be kind of self explanatory as to why, but if you have questions, let me know. You need to tell the client what the fees are and share if anything changes. They can be contingent on the outcome, but it needs to be clear and it needs to be in writing. The lawyer shall not collect fees in domestic relations claims, contingent fees for defendant in a criminal case. You can't divide the fees between yourself and a lawyer in another firm, but you can, but only in proportion to the services charged, if the client agrees, and if the total fee is reasonable. So you can't bring in other lawyers from other firms and just jack up the price. The fees need to be reasonable. So this is just a bunch of rules on how we're allowed to charge and what we're allowed to charge as lawyers. And all of those factors that I talked about, you're able to increase the amount that you charge based on what is required in the representation, stuff like your own skill you can charge more for, or whether or not this is a new legal issue. You can't just bring in other firms and jack up the price, stuff like that, and you can't collect contingent fees on representing a defendant in a criminal case or any fee in a domestic relations matter. The payment, if it's contingent on the securing of alimony or support like that, because that would just be you burdening somebody for life instead of cutting off the fee. Yeah, we will jump over to 1.6, confidentiality. This is a big one. And you know what? It is so big, I am actually going to top off my coffee real quick, and then we will be back. Let me just mute this, and I'll be back. Alright, I am back. I'm realizing that this probably isn't the best way to explain all of this, so let me try and... Okay, you know what is probably going to be better to just go through one of these outlines and break things down from there, because this person looks like they actually have a solid outline. So let's just go through that. Okay, so professional responsibility. Everything that we have is broken down into different categories. So the first category is stuff that pertains to the client-lawyer relationship and your relationship with individual clients. And that can be broken down even further into your duties to the client, and then your duty and what your client's rights are, blah, blah, blah. Duties to others, what you're able to do with publicity, conflicts of interest. These are all different subsets, so we'll go through these in order, and if you have questions, we'll go from there. I'm not going to go through the multiple choice questions. They're kind of pointless, in my opinion, after taking a look at them, and I'm also not going to just go straight through the rules like I was, because that's too dense. You guys probably aren't enjoying that or picking anything up from it, so we'll go through them like this. So, first up are our duties to the client. First, we need to be able to competently represent the client. Competent representation, or Rule 1.1. We already went over this, but to competently represent a client, you need to have legal knowledge, skill, thoroughness, and preparation that's reasonably required for the representation at hand. You cannot neglect a legal matter, and you must not take on a matter that you know you're incapable of handling. So if you don't know about a specific type of law, you can't take it on unless you think that you'll have the time to brush up on it enough where you can competently handle a case in that area. My example earlier was, if you work on trusts and estates, you shouldn't be taking on commercial litigation cases unless you have so much time on your hands that you can teach yourself how to be a commercial litigator. But in that case, it's not worth your client's time to have you study up on all of this. So instead, they should just go to a different firm, and you're kind of wasting their time if you take on that case. Next up is diligence. Rule 1.3. The lawyer shall act with reasonable diligence and promptness. There's no procrastination. If you miss a statute of limitations or you miss a deadline, you are responsible. Act as a zealous advocate. This was actually recently removed from the Arizona rules on professional responsibility because lawyers were using this as an excuse to act like assholes and just scream and go too hard on their client's behalf. So that's been removed. Another part of diligence, you need to carry things through to their conclusion, and if you need to terminate the relationship, you do it in writing, you communicate that to the client. So finish the case, and if you can't and you need to terminate it, follow the proper procedures for that. Do it in writing. Don't answer any more of your client's questions, because if you do, then they'll say, I still thought this person was my lawyer. You need to cut it off. Next up, part of your duties to your client are confidentiality. Absent informed consent of the client, you must not reveal information relating to the representation of the client unless the disclosure is impliedly authorized in order to carry out the representation or permitted by the exceptions. So you can't tell anybody anything about the case that you're working on or anything related to your representation of the client unless the client says you can tell people about this case, you can tell people about this specific thing, but that still requires informed consent, which is you letting them know about the risks of it, advising them that they should seek the opinion of outside counsel, and then letting it be up to them what they want to decide. And then typically they'll need to convey in writing that they have given their informed consent. Some exceptions and stuff that you're allowed to talk about: to prevent reasonably certain death or substantial bodily harm. If your client tells you that they're going to go home and shoot their wife, and you know them well enough to know that that's a very real possibility, that's something that you can tell other people about, even though it typically would be covered under confidentiality. To prevent the client from committing crime or fraud reasonably certain to result in the substantial injury to the financial interest or property. When the client has used or is using the lawyer's services in furtherance of the crime, you can tell people, you can call the police if you think that your client's about to commit a crime. They've given you information that you think is substantial to them going to commit a crime. Another exception, you can prevent, mitigate, or rectify substantial injury to financial interests or property of another person. So if your client is reasonably certain to go and do something, you can tell people about it if it's something that's dangerous and will have economic ramifications. You can reach out to the bar to get their opinion on whether or not what you're doing is in violation of the rules. So lawyers will often call hotlines or send emails to the bar and ask them, hey, I have this case where I'm doing such and such. I'm thinking of doing this. Is it a violation of the rules? And the bar is allowed to respond, and the lawyer is allowed to do that and disclose some client information and some information representing to the representation of the client if they're seeking advice from the bar about whether or not they're violating the rules. To establish claim or defense on behalf of lawyer is between lawyer and client. So if you think your client's going to sue you, you can disclose some information about it, so that way it would create a defense in the future. And if a judge orders you to disclose confidential information, you are allowed to. It's permissible under the exceptions. This continues even after the lawyer-client relationship is over. You can't disclose details of the case or relating to the representation of the client. Physical evidence isn't privileged, so say you're working as a criminal defendant and there's a murder weapon. The fact that there's a murder weapon isn't privileged information, but if your client tells you where the murder weapon is, that's privileged. You don't need to share that. Anything that you do have, though, so if the client turns over the knife that they used to kill someone, you need to turn that over to evidence, and it will be brought into the court. Next, another duty that you have to your client is safekeeping property. This relates to the lawyer's role as a fiduciary. You need to hold on to any funds that your client wins in a lawsuit or anything that they give you as payment. You need to hold it in a separate trust account. You need to let them know what the interest rates on that trust account are. You can put your own funds in a trust account only for paying the bank service charges on that account, so you can't put your money into the client trust account just to keep it there. You can only put your own money in if it's to pay the service fees. And you also must deposit all advanced legal fees and expenses and withdraw only when the fees are earned or the expenses are incurred. So oftentimes clients will pay you a lump sum of money up front for your representation of them. You can't take that into your own personal account until it's been earned or until the expenses that money is for have occurred. So say you, as part of the representation, you need to pay an expert witness, you can withdraw money from that account so that way you can pay the expert witness when that fee occurs. But you can't take it out and be like, hey, I have this money here. Until the fee actually comes into effect, it needs to stay in that separate trust account. You need to keep records on everything that you have. When you get money for a client, you need to promptly let them know and promptly deliver the funds. Again, no procrastinating stuff. If there's any money that's in dispute as to whether or not you actually earned it or anything, like your client is saying that you didn't earn X percentage of the money, you need to keep that in a separate account until you can resolve the issue, and the property has to be adequately safeguarded. Okay, sale of your law practice. A lawyer or law firm may sell or purchase a law practice or area, including goodwill, if the seller ceases the practice of law, the entire practice or area of practice is sold to one or more lawyers or law firms, written notice to client regarding the sale, the client's right to retain other counsel, and the client's consent to transfer presumed if no action by client within 90 days, then they've accepted. Fees charged to clients may not be increased because of the sale. So you can sell your law firm or you can sell a practice area so long as the seller is done practicing law. And then when you sell it, it needs to follow just the set of rules. When you're acting as a witness, Rule 3.7, so attorney as a witness. And generally, you can't be an advocate, which means you can't represent a client if you're likely to be a necessary witness. So there's a little bit of leeway there. Necessary witness and witness are different. So say you were general counsel at a company and you have specific information about a set of transactions that the company was doing. You, the head accountant, and the CEO all know about this info. And it's very likely that somebody needs to be called into court because of their knowledge of that info. Are you a necessary witness? Based on the case law, probably. Even though there are other people that could answer it, it's something specific that you can also answer, so the court will probably say that you're a necessary witness, so you can't represent the company in that type of situation. There are some exceptions, such as if you're testifying on an uncontested issue. So if it's something that both parties have stipulated to, you're able to testify on it. But typically that's not even necessary if the parties have stipulated it. If the testimony relates to the nature and value of your legal services rendered, so this is when your client is disputing that that you haven't earned what you've done, or when opposing counsel is asking, like, what type of representation have you done, you're allowed to testify on that. And if there will be substantial hardship on your client if you were disqualified as a witness. You also may act as an advocate in trial in which another lawyer in your law firm is likely to be called, unless another rule prohibits that. So say you work at a big law firm and someone from a different department's probably going to be called as a witness, you're still able to represent the client. Okay. The next subsection are the client's rights. So the client has a right to be informed. This relates back to Rule 1.4. You need to promptly respond to any reasonable request for information, whether they're from your client or opposing counsel, so long as it's something that's permitted that you share it. You need to explain the matter sufficiently to allow the client to make that informed decision. You need to reasonably consult with the client regarding the means for how you're going to accomplish the objectives. Remember, relating back to relating back to the separation and what lawyers and clients do, the client gets to decide what the objectives of the representation are, so what they want, and you get to basically decide the means, but you'll reasonably consult with the client regarding that. This is actually Rule 1-2 that we'll get back to in just a second. You need to keep a client reasonably informed of the status of the case. If the case gets dismissed and thrown out by a judge, you can't just not tell the client. You need to be reasonable and let them know everything. You need to consult with the client regarding the limitations on your conduct due to the rules or other laws. So you need to let your client know when you aren't allowed to do something that they're asking you to because of the rules or because of another law. If your client is asking you to do something that's in violation of the criminal code of your jurisdiction, you need to let the client know, hey, I can't do that, that's a crime. And you need to consult with them and let them know what their other options are, basically. There are some certain special circumstances. These are typically covered by other rules, so we'll get to those when we get to those other rules. But back to Rule 1-2. This is where the separation in powers and what each party is allowed to do comes back into effect. So generally, the client decides the objectives and the attorney decides the means for how those objectives are reached after they consult. So Rule 1-2 and 1-4 really work together. The client decides what they want the representation to be about, and you decide how you do that. The attorney has the final say on technical questions or the strategy and procedures. So you have the final say on how something is going to work because you know the rules of civil procedure or criminal procedure. You have the final say on that. The client has the final say on the expenses. If a client doesn't want to pay for expert witnesses, you can't just bring in an expert witness and be like, the client will pay it later. No, if the client doesn't want to pay for certain expenses, then you can't use those extra resources. This is typically seen with stuff like expert witnesses or doing certain scientific testing. You can't just do it on your own and expect the client to pay it. You need to get their permission first by consulting them relating to Rule 1-4. The client has the final decision on when to settle a matter, and the client in a criminal case has the final decision on what plea they should enter, whether or not they should waive a jury trial, and whether or not they testify. So, clients, if a settlement is offered, they get to decide whether or not it's accepted. If it's a criminal case, the client gets to decide whether or not they're pleading guilty, not guilty, no contest. They have the final say on that. And they also have the final say on whether or not they want to testify at their own criminal trial. You can't force somebody to testify at their own criminal trial, even if you think it would be beneficial. You can advise them that it would be beneficial, but you can't force them to go and testify at that trial. The attorney may limit the scope of the representation if the limitation is reasonable and the client gives informed consent. Again, you can modify this slightly by reducing the scope of what you're doing, so long as it's reasonable under the circumstances. And again, informed consent is you let them know what you're thinking, tell them to seek outside counsel if they want it, and then ask them to, preferably in writing, give you their consent. And then you must not, as a lawyer, counsel your client to engage in or assist them in committing fraudulent or criminal conduct. You're allowed to discuss the consequences of them doing something. So if they come to you and say, hey, I'm thinking of shredding these papers, is that illegal? What are the consequences? You can let them know, yeah, that might be destruction of evidence. Here's the standard. Here's what you'd likely be charged with. And if you're found guilty, here's how long you'd be in jail or prison. But you can't tell them to go and shred papers. Stuff like that. If the client insists on doing something that's illegal or fraudulent, even after you've counseled them against it or told them what the ramifications could be, you're required to withdraw from representation, and Rule 116, which we'll get to in a minute, covers how you withdraw from representation. Client under a disability. So this relates back to informing the client when they're incompetent or they're a child. This is Rule 114. A client's capacity to make adequately considered decisions is diminished if they're a minority, have a mental disability, or there's another reason, and you may take reasonably necessary actions to protect the client at risk of substantial harm. You typically maintain a normal attorney-client relationship as far as is reasonably possible, and you'll often seek a guardian to be appointed to the individual in a circumstance such as that. This is just talking about when the client is of a diminished capacity, what you should be doing. You'll take reasonably necessary actions to protect them. You'll try and keep things as normal as possible, and you'll seek a guardian be appointed for them. These are just extra things that you do if the client is of diminished capacity or doesn't have the correct decision-making capacity. Okay, whether or not you're able to represent the client. First is conflict of interest, which is a very, very big thing. Most lawyers don't realize just how big conflict of interest is and how much it encompasses, but if you have a conflict of interest, you're disqualified from representing your client unless there's some very rare situations where you can get informed consent. So, when lawyers associate, no lawyer may represent a client when anyone alone will be prohibited from representation unless that prohibition was due to personal interest or unless waived by the client. And a law firm is not prohibited from representing a person with interest materially adverse to a client of a lawyer who has terminated association with that firm unless it's the same matter a current lawyer has protected information. So this is one of the more in-depth rules, and we'll break that down here in a sec. Okay. So, if you and some other lawyers are working together, you can't represent a client. So if you have a small firm, you can't represent a client if any of you individually would be prohibited from doing so due to a conflict of interest. If the conflict was due to personal reasons, you still can represent the client, or if the client waives their informed consent, you can still represent them, but again, you need to follow the informed consent rules, blah, blah, blah. This doesn't apply to actual law firms, though. If one lawyer at a law firm is trying to represent someone that has a conflict of interest with another lawyer, and that other lawyer is fired or quits or leaves, the law firm is able to represent that client as long as it's not the same matter that the other lawyer who's no longer there was representing them in or conflicting them in. I know that's kind of confusing. That's something that I need to review myself. And for those of you who didn't watch it, yesterday I actually released a video on how I study for exams and how I tend to do well on my finals, and it related to the idea of teaching others instead of just sitting there and studying yourself. And that's the reason why I've been doing the live streams like this. I highly recommend that you go check it out. And in it, I mentioned that whenever I'm struggling to explain something to the chat or whoever I'm explaining it to, that means that I don't understand it as thoroughly as I should. So when the review session's over, I typically go back and look over that information. So I know that when I'm done here, I'll need to go back over Rule 110 and conflict of interest, and I'll probably also need to go over withdrawal in general, just anything relating to representation, because I've been struggling to explain it. That means that I need to go and study it again. And also, I highly recommend that you check out that video. I put a lot of effort into that one, and I'm proud of it. Okay. Enough about that. Back to the rules. Withdrawal. This isn't alcohol withdrawal. It's not drug withdrawal. This is you withdrawing as representation for a client. So this is when you're able to stop being somebody's lawyer, when it's permissible, and when it's mandatory that you stop. So this relates to Rule 116, and again, everything is interconnected. There's the clause in Rule 1.2 that says if the client insists on committing criminal activity or fraudulent activity, you're forced to withdraw, and that's under 116. A mandatory withdrawal. The lawyer shall not represent a client or shall withdraw if the attorney's disability impairs their ability. So say you get in a car accident or you get diagnosed with cancer, you're forced to withdraw from representing your client if something happens to you where you get a disability that would limit your ability to represent that client. You're forced to withdraw from representation, and you shall not represent a client if the representation is illegal, they're trying to do something illegal, or if you're fired. If you're fired by your client, you can't go into court the next day and talk to the judge about the case and continue to work on it. You're forced to stop. Permissive withdrawals. A lawyer may withdraw from representing a client, and this is important. I didn't mention this for any of the prior rules because they aren't partisan like this, but this relates a lot to LSAT logic questions. Shall and may. Shall means that you have to do something, you have to follow that rule, you need to stop representing a client. May is may. You're allowed to. So a lawyer may withdraw from representing a client, or you may stop working on a case if it wouldn't materially harm the client persists in criminal or fraudulent conduct involving the attorney, the client used the attorney's services to commit past crime or fraud, the client's objective is repugnant, that's kind of up for interpretation by the lawyer, the client breaks a promise to attorney and is given reasonable warning, so if they fail to pay fees or they're uncooperative, stuff like that, you give them reasonable warning in that circumstance and say, hey, if you don't pay me, I'm not going to keep representing you. And if they still don't pay you, then you're able to withdraw, so long as it wouldn't materially harm the client. You're able to withdraw if there's a financial burden on you. So say it's costing you way too much money to be taking on the case, you're able to withdraw. This typically will happen in a lot of criminal cases, but in those cases, you're still kind of forced to stay on because it would materially harm the client or prejudice the judge against them if you were withdrawn, or if there's other good cause. So this is one of the very few things where there's expansive language. Typically, all the language in the model rules and rules of professional conduct across all jurisdictions are restrictive. They say what you have to do, what you're limited to. Here, we have language where it's expansive. If there's an other good cause that's not listed here, you may be able to withdraw. Okay, then 3, actions taken upon withdrawal. You need to give notice or get permission. If ordered not to withdraw, the lawyer must continue despite good cause. So you need to give notice to the judge of the case that you are withdrawing, and in some cases you need to get permission. The judge can say for any of these reasons that you aren't allowed to withdraw. Even if you have a good reason, the judge can still force you to continue representation of the client. some factors relating to that, you need to reasonably protect the client's interests, so you can't withdraw the night before trial. You need to allow time to get them allow time for them to get new counsel. You need to refund any fees that you haven't earned. That's part of why you're forced to keep it in a separate account. And you need to return any property. This includes any evidence, anything that the client has given you just to hold on to, and depending on the jurisdiction, it will include work products. So any files that you have, any papers that you've written up, those may need to go back to the client. And those are our duties to clients and some of the rights that clients have. Now let's move into our duties to other people. This includes duties to third parties, duties to the court, and duties to opposing counsel, blah, blah, blah. After that, we'll get back into conflict of interest, and we'll wrap things up after that. So, duty to others. First up, we have third parties. Rule 3.4, fairness in opposing party and counsel. You must not obstruct access to or counsel another to alter, destroy, or conceal evidence, or counsel assist another person to do such an act. You basically can't tell people to go and impede the other side. And you can't go yourself and just stand in the way of opposing counsel or opposing parties. There's another little rule in here, Rule 4.4. You need to refrain from examining material you received in error. So if you accidentally get an email from opposing counsel that you weren't meant to, you aren't allowed to examine it. The second that you realize that it's something that you shouldn't be seeing, you need to cut off and stop and inform the other party that, hey, you sent me this on accident. It could have bearing on the case, and it could put your client at risk. I stopped reading it here. There you go. You can't falsify evidence. Very straightforward. You can't make frivolous discovery requests or fail to comply with discovery requests. So you can't just bog the other party down with send us everything. Or if the opposing party has a reasonable discovery request, you can't just fail to send them the information. Must not allude to irrelevant matters or give personal opinion at trial. Basically just stay on track. Must not advise non-client silence unless a witness is a relative or employee of client, and silence is not detrimental to non-client witness. So you can't tell somebody to shut up and don't say anything at court unless that person is a relative of your client or an employee of them. If they're just some random person on the street, it's their choice whether or not they want to testify at trial. So say there is a public shooting and this old grandma sees it happen. You can't go and tell the grandma, hey, I really suggest that you just don't say anything and you don't go to trial and you stay silent. You can't do that. It's her choice whether or not she wants to testify and be a witness against your client. Truthful statements to others. You may not make false statements of material fact or law to a third person, so you can't just tell witnesses or opposing counsel or anybody just false facts about the case or false statements of law, and you must disclose material facts to avoid assisting client in crime or fraud. You must not communicate with another attorney's client without consent or legal authority. So you can't go and just start talking to the opposing client, the opposing party. You need to follow the rules to talk to them, which typically requires a deposition or some waiver to be signed. This bar applies to communications relating to the subject matter of the representation, with certain exceptions in place, you're able to talk to them about stuff that's not related to the case, but even still, you probably shouldn't, just because chances are you'll just get yourself in trouble. You're running the risk that you really shouldn't. Okay, unrepresented persons, Rule 4.3. So these are people that aren't part of the trial. You can't imply disinterest. So if a witness comes up to the party or comes to you, you can't just pretend like you aren't part of the case. You need to let them know, hey, I'm representing the defendant in this case. Just so you're aware, this is my stance, this is what I'm doing. You can't pretend like you aren't representing somebody if a witness comes to you to like seek advice. You need to make reasonable efforts to correct misunderstandings that anybody might have, and you must not give legal advice other than to advise them to secure counsel if you're aware that there might be a conflict of interest. So, relating back to that witness example, if you think that there could be a conflict of interest, so the client that you have and the witness's testimony would be detrimental to your client, you can't give that witness legal advice other than tell them, hey, go get your own lawyer, because any legal advice that you give them might be to the benefit of your client and might be unfair to the execution of justice. Respect for rights of third persons. You can't embarrass, delay, or burden a third party, and you must not violate legal rights of a third party. So you can't just go around disparaging witnesses and other people. You need to actually treat them like people and like they still have legal rights. Okay, responsibilities of partners or supervisors. This is if you're working at a law firm. Rule 5.1. You need to make reasonable efforts to ensure that you're directly supervising conform to the rules. You basically need to make sure that all of the associates at your firm, if you're a partner, aren't going around directly violating the law and violating the ethical rules or professional responsibility rules. You're held responsible if you order or ratify unethical conduct or fail to take remedial action. So if you tell a lawyer or an associate to go and do something that's a violation of the ethical rules, you're responsible. They're also responsible, but you will be charged. You'll receive a bar charge too. And you're also responsible for the conduct of non-lawyer assistants, so stuff like paralegals and secretaries. If you know about their conduct and you don't take any remedial action to stop that conduct. Subordinate attorney responsibilities. Rule 5.2. These are just basically structural. Say you work at a law firm, these are what you should be doing when you're the supervisor or the partner, and what you should be doing when you're the associate attorney or someone on a lower level. So the subordinates or lower level attorneys are bound by the rules, and it's not a defense that you're acting under the direction of somebody else. So if your boss or your supervisor tells you to do something that you know is in violation of the ethical rules, it's not a defense if you say, oh, so-and-so told me to do it. No, you have the same level of responsibility as any other lawyer. You need to understand the rules, be aware of them, and follow them. There's no excuse for just following the instructions of somebody else. If the question is iffy, so if it's arguable either way whether or not it would be an ethical violation, you can rely on your supervisor's opinion if it's a reasonable opinion. So say one of the big things is lawyers aren't supposed to have sex with their clients. it's iffy as to whether or not somebody would still be a client after they've already like left the firm. There's the possibility that the case could end up going to court on an appeal, but they aren't currently your client. You can ask your supervisor, hey, is it okay if I hook up with that ex-client? I know that they might want to do an appeal, but we technically aren't their lawyers right now. What do you think? And if the supervisor says, you know what, I think it's okay, go for it, that could be seen as a reasonable interpretation of a fuzzy ethical rule, and you can rely on something like that. Okay. Any questions on any of that? Nope. Okay. You have a couple of different duties towards the court itself. Let's see just how much more of this we have. Okay, we have about a page left on these duties. So, duties towards the court. First up, we have Rule 3.3, candor towards the tribunal. So, what you're allowed to say to the judge and jury, basically. You must not make false statements of material fact or law or fail to correct previously false statements. So, you can't go into court and lie. Or the big one is law. So, you can't make false statements of law. You can't go into court and tell the judge, hey, this is the case law in this jurisdiction. This is how this should be decided, and just be outright lying. So, for example, in criminal law, different crimes are split up into specific intent or general intent, depending on the jurisdiction that they're in. And in most cases, stuff like murder is specific intent. You can't go around telling the judge that it's general intent, and therefore you can use a different level of mens rea standard. You need to actually tell the truth. And if you do make a false statement and you know that it was false, you need to correct it. You must disclose material facts to the court when necessary to avoid assisting in a crime or fraudulent act by the client. So if your client tells you something that you're required to disclose, you have to tell the court. And you must not offer evidence known to be false. This just relates to perjury. Elicit truths from the client. If that fails, seek to withdraw. If that fails, disclose to court and chambers, blah, blah, blah. You must disclose legal authority in controlling jurisdiction known to be directly adverse to the client's position. So you need to tell the court if the prior case law is against your client. You can't just pretend like certain law doesn't exist. Meritorious claims. Rule 3.1. You must not bring frivolous claims. There has to be an actual basis in law, like the law permits this type of claim, and there also needs to be a basis in fact. So there needs to be a factual background that would permit or support the idea that this would end up being decided in your client's favor. You may defend a criminal case and require every element to be established. So this is different from civil cases. In criminal cases, the prosecution is required to prove every material element. Impartiality and decorum of tribunal must not illegally influence the judge, juror, or prospective juror. No ex parte communications, and no disruptive conduct. So, you can't try to influence the judge or the jury in any way that's illegal. So there's this saying that I personally love. A good lawyer knows the law. A great lawyer knows the judge. But you can't be going around buying judges drinks and taking them to the golf course trying to influence them. You also can't be doing the same with jurors. In fact, you shouldn't be speaking to the jurors at all, or these prospective jurors at all. No ex parte communications. You shouldn't be going around trying to talk to the judge and the jury behind the other party's back. And no disruptive conduct. Just, you shouldn't, I know it's very entertaining, but you shouldn't be doing all these theatrical things in a court like you'd see in Better Call Saul. You shouldn't be doing things that kind of disrupt the nature of the court and cause people to gasp and stuff like that. It's very good, very theatrical, and can actually be very beneficial to your client, but the rules don't allow it. So any of you theater kids out there, you aren't able to bring your experience from that into a courtroom. Expediting litigation. A lawyer must make reasonable efforts consistent with the interest of the client, so you need to actually just do what's in the best interest of the client and bring things in a reasonable manner and reasonable amount of time. And then I think, okay, we have two more for this. Special duties of prosecutors, Rule 3.8. This is when you're prosecuting a criminal case. These are just extra things that you as a prosecutor need to do and rules that you have to follow. So you cannot prosecute unless there's probable cause, and you're not entitled to absolute immunity if you made a false statement for the arrest warrant. So when you're filing for an arrest warrant, you need to give certain information to the judge, and if you lie and make a false statement, you don't have absolute immunity. You need to protect the accused's right to counsel. You can't prosecute somebody that doesn't have representation unless they intentionally decide to represent themselves, and this is part of the reason why we read Miranda rights and let people that are being arrested know what their rights are and that they have a right to a lawyer. You must not seek waiver of rights of the unpresented accused. Oh my gosh, my mind is slowing down. So you can't seek that. You can't make a party sign away their rights if they aren't represented by another person. You must timely disclose evidence which negates guilt. So if you're a prosecutor and you find something that would let the defendant just walk free, you need to actually disclose that. You can't hide the evidence. You must not subpoena a lawyer to present evidence about a client unless information is not protected by privilege, the evidence is essential, and there is no alternative means to get the information. So you're able to subpoena another lawyer to testify about their client or give info about their client, so long as that information isn't protected under privilege. The evidence is essential to deciding whether or not the client's guilty, and there's no other way to get it. You must refrain from and prevent others from commenting to public regarding the accused except under Rule 3.6. 3.6 is trial publicity, which we'll get to, but you have to tell other lawyers at your firm not to talk about the accused and stuff like that. When faced with new credible evidence of a wrongful conviction, you must promptly disclose it to the court. If the conviction is in prosecutor's own jurisdiction, it must disclose evidence to defendant and investigate. And if the evidence is clear and convincing, must seek to remedy the conviction. So if evidence comes forward that you put the wrong person in jail, you need to actually bring that forward. Again, no hiding the evidence. And accepting appointments by the court. Rule 6.2, you must not avoid court appointments unless there's an unreasonable financial burden, it's a repugnant client or case, or it would violate the rules for you to represent them. So there are a couple of ways that you can get out of being a court-appointed prosecutor, but they aren't, or being a court-appointed lawyer, and typically defendant, but they're very strict. Next up, we have trial publicity. This will probably be the last thing that we do. After this, I'll probably cut it before conflict of interest. I'll probably study that on my own because that's something I struggled with before. And yeah, but let's do trial publicity quick. So Rule 3.6. You must not make out-of-court statement a reasonable person would expect to become public where there is a substantial likelihood of materially prejudicing proceedings. So you can't make statements out of court that a reasonable person would think would become widespread and known by the public if it's something that you think would materially prejudice the court. So you can't say things to reporters that you know will get spread about that are reasonably likely to get back to the jury and influence their decision. There are some things that are permissible out-of-court statements, so such as the general nature of the crime or the claim or the defense, information that's in the public record, the general scope of the investigation, scheduling or disclosing result or of stage of litigation, or request for public assistance or information, warning of danger if there's a likelihood of harm, rebuttal to comments made by others to mitigate prejudice, and in criminal cases, identity, residence, etc. of the accused, information necessary to apprehend the accused, facts regarding the arrest, and identity of the officers involved in the arrest. So, these are things that you're allowed to tell reporters. You're allowed to basically say. So, you're able to say, this is a criminal claim based on murder. This is the defense that we're using. They're charging us with second-degree murder. We're defending based on the grounds that it would likely be manslaughter. You're able to say that. Stuff that's in the public record, so how long they've been detained for, stuff like that. General scope of the investigation, pretty straightforward, talking about just what the case is about. They're investigating so-and-so for second-degree murder. Scheduling or disclosing of the result or stage of the litigation, you're able to tell the public and tell reporters and stuff that, hey, we have a hearing scheduled on this day. Currently, there's a settlement offer on the table, blah, blah, blah. You're able to say that. You're able to request public assistance or information. Like, if anybody knows the whereabouts of person X or of accused, please let us know. If anybody has any information relating to this commercial liability claim, so if anybody has had mesothelioma, please give us information. Warning or danger if there's a high likelihood of harm. So if, this is typically in criminal cases again, if there's the likelihood that somebody is going to commit a crime, so say the defendant is out on bail, you can say, this person is charged with aggravated assault and battery. There's a likelihood that he will harm other individuals. Please be aware, please be on the lookout in this location. If the other party says something that isn't permitted, you're able to rebut it and try to mitigate that prejudice. And then in criminal cases, you're allowed to say even more. Like, you're able to say, oh, the accused is John Smith, who lives at 113 Main Street. Please let us know. He was last seen in the downtown neighborhood wearing a black sweatshirt and jeans. He's a white male of average build, blah, 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 blonde hair, brown eyes, information necessary that would to apprehend the accused. And then once someone has been arrested, you can say, John Smith was arrested on May 3rd at 2 p.m. just outside of this bar. He attempted to flee from the police, but was apprehended by officers Johnson and Gonzalez. You can add in information like that. So these are all the things that you're allowed to say to reporters and to the media outside of court. And let's quickly take a look. Conflict of interest. This is something that I'm probably going to review on my own because I was struggling to explain it before. And like I said, if you haven't checked out my video from yesterday, about how I study and stuff, feel free to check it out. It explains a lot of my rationale. Practical matters of lawyering. I'm just skimming through this to see if there's anything else I want to cover during this live stream. I might cover some of this real quick. Advertising and solicitation. Bar admission and discipline. Okay. We'll quickly cover some of the practical matters of lawyering. So first up is fees. The fees need to be reasonable, and the factors that you can use to determine whether or not a fee is reasonable, so what you're able to collect from your client, are the time and labor that you put in, the likelihood that this type of work is going to preclude other work. So if you're representing a big corporation, you're not likely going to be able to represent other corporations, so you can weigh that in on how much you want to charge them. The novelty or difficulty of the case and the skill required to properly perform it. So if this is a really new legal issue that nobody has decided before and it would require a lot of research, you can charge more for that. The customary fee charged locally. How much do people typically charge for this type of case? That needs to weigh into whether or not it's reasonable. The amount at stake and the results that you obtain. So if what's at stake is billions of dollars in a commercial litigation suit, then you can charge more. And if you win and you end up getting a settlement where your client only pays out $100 million when they could have been paying out $3 billion, you can charge a little bit more for that. Nature and length of professional relationship, you can charge certain clients more or less depending on how long you've known them and what your relationship is. So if it's a new client, you can charge them a little bit more because you don't really know them. You need to get all this background info. If it's an old client, you can charge them a little less because they bring you regular work. The experience, reputation, and ability of the attorney. If you're a really good lawyer, you can charge more money. And if you're known for not fucking shit up, you can charge more money. If you're a bad lawyer who's known for causing trouble, it's not really reasonable that you charge an absurd fee. You can't double bill, which is pretty straightforward. Something else relating to whether or not it's reasonable is what time limitations you have on the case. So if it's a very short time window, you only have a week to prepare your brief, then you can charge a little bit more. And depending on whether or not the fee is fixed or contingent, you can adjust the fee. So if it's contingent, you can charge a little bit more because there's a chance that you would get nothing. If it's fixed, you will probably charge a little bit less. Okay, so scope of representation, basis of fees shall be communicated to the client, preferably in writing. Contingency fees are permitted in criminal and domestic relations cases. Domestic relations, that means that you can't get a contingent fee if that contingent fee is based on securing alimony or child support, stuff like that, because that would be just a lifelong burden as opposed to an actual fee. You are hindering the client in that situation. And then criminal defense, you can't charge a contingent fee on them winning because it kind of creates bad incentives. If you don't think that you're going to end up getting your client off, then you're more likely to just not represent them as zealously as you should or represent them as well as you should just to move on to a different client. But if it's a fixed fee, you're going to represent them as best as you can regardless. Regulating the fee agreement, it has to be in writing. It has to state how the fee is calculated. It must tell the client what expenses are going to be deducted, so what you're charging money for. And it must provide the client with a written statement detailing the information at the conclusion of the case. So once the case is over, you need to give a client just a form that says, here's what you paid me for, here's where the fees went to these tests, to these expert witnesses, this is everything. And you need to keep records of all that stuff for up to 5 years, as we mentioned, with keeping clients' money and property in separate, in separate accounts. Oh my god, my brain is fried. This is what happens when you have 2 weeks of finals straight. You just reach a point where there's nothing that your brain can do, and it's fried. Luckily, everything will be over by this time tomorrow. Okay, division of fees between lawyers not in the same firm may be made only if they're proportional to the services performed or there's joint responsibility. So you can't just pay. If there are multiple firms working on something, you need to pay based on what amount each firm did, like the amount of work each firm did. The client has to agree in writing to the division of fees between different firms, and the total fee needs to be reasonable. Voluntary pro bono work. You should aspire to 50 hours of service, but this is not required. Substantial majority should go to persons of limited means or organizations designed to assist them. So, this is something that's not an actual rule in the typical sense of rule. This is a suggestion. This is to make lawyers seem nicer and like we care more about the community. They say that we should aspire for 50 hours of pro bono work per year. Some firms actually require their lawyers to take on a certain number of pro bono cases, but it's not required by any of the ethical rules or professional responsibility rules. A lot of law schools, though, will require their students to do pro bono work while they're in law school. Here at ASU, they don't require that, but a lot of schools will require students to go out and do pro bono work. It's still very common that students will do it even when it's not required, and a lot of lawyers go above that 50 hours, but there's no actual requirement that you go out and do pro bono work. All right. Advertising and solicitation. Okay, we can finish this and then I'll go through and do conflict of interest on my own. Communications concerning services. So this is when you're advertising. You can't make statements that are false or misleading. Statements are misleading if misleading factors are material misrepresentations or omissions of fact or law. You can't lie in commercials about what you do. Creation of unjustified expectations about results. You can't say, I will win every case and get you millions of dollars. You can imply it, but there needs to be some background behind it. You see this a lot with a lot of personal injury firms. They'll have a running list on their commercials, just going through, like, here's $3 million, $2,400,000, and they'll just have this list taking down in the background of the commercial of all of the cases that they've won and how much they've either received or they've settled for. And if those are actually true, then it's permissible. It creates an expectation about the results, but it's not unjustified. There's actual evidence that they've received these results in the past. You can't lie, though, and just say, hey, regardless of what case you bring me, you're going to get $2 million bare minimum. You can't compare your services with another attorneys or another firms unless there's actual, like, substance or reason to believe it, like if there's actual facts behind it. You can't say, I'm just as good as this big law firm. You need to have actual facts showing it. Requirements for ads. they're subject to other rules and to state regulations. Lawyers can advertise through written stuff, recorded means, or electronic media. There's actually a couple of funny cases of this. So, lawyer advertise mint beer. Okay, this one's actually kind of funny. I'm hoping that this will actually play through. This is a law firm. You know what, I'll just let this play and then we'll go through it after. And this is the potential issue that they ran into. These lawyers advertise all over social media and all over just the internet in general and with their commercials, and their tagline is word DTF. And DTF in this situation stands down to fight for you. This very obviously has some issues with it, and there was actually a bar charge brought against them for violating the advertising rules, where they had to explain to the judge what DTF meant. So yeah, this is actually permissible though, but you can see where some issues might come into place. So yeah, this is the type of stuff that rule is concerned with. Let's jump back to this, but you're able to advertise, but it's subject to the other rules in the model rules and whatever state regulations you have. You need to include the name and official address of at least one lawyer or firm that's part of the advertisement. A lawyer shall not pay value to a person recommending services except reasonable costs of advertising, usual charges of approved qualified referral services, pay for law practice in accordance with the other rules, and refer clients to another professional under an agreement if reciprocal referral is not exclusive and client informed of agreement. So typically you just can't pay people to send you clients. This is the thing with like ambulance chasers. They'll have people run into hospitals like after people that were in serious injuries and send them and give them the names of personal injury lawyers, and those lawyers will get work from these people, and they'll just pay these people to go and give their information to victims. That's impermissible. There are some ways around it though, like you're able to pay for advertising, you're able to pay certain verified referral services, but other than that you can't outright pay people to send you clients. Solicitation. You shall not solicit people to become your clients, so shall not solicit in person, on the phone, or by real-time electronic means when a significant motive is pecuniary gain, so if you want to make money, unless the person contacted is a lawyer or has family, personal, or prior professional relationship with the lawyer. So you can't reach out to random people and be like, hey, I'll be your lawyer, I heard you're having this issue, I'll be your lawyer, just make sure that I get paid. You can't do that. But if you have clients that you're like, oh, I read in the news that this company I've worked with in the past is potentially dealing with some FDA violations. They manufacture creatine or something, and they're dealing with an FDA violation. You can call them up and be like, hey, do you need a lawyer? Because you've worked with them in the past. You can't be a part of prepaid or group legal services that plan to solicit people for memberships. This kind of relates to stuff like LegalZoom. You can't be a part of that because it would be the part of their plan to make money is to solicit memberships. Letters are permissible, so letters are impermissible when the person has made known a desire not to be solicited or solicitation involves coercion, duress, or harassment. But if none of those are present, you can send out letters to people and be like, hey, if you ever need a lawyer, let me know. 30-day ban on targeted direct mail solicitation does not violate First and 14th Amendments. This is a case that some lawyers tried to make that, hey, you preventing us from sending out mail soliciting clients is violating our First Amendment right to free speech and 14th Amendment right to due process. And the courts have held that it's not a violation. You're still able to freely communicate. You just can't solicit in these manners. Targeted letters must say advertising material on the envelope, and political contribution precludes accepting government legal work. So if you give money to political parties, you can't accept government work in most circumstances. There are some exceptions to that. Communicating fields of practice. You shall not imply being a specialist in a certain field unless you're a patent attorney, an admiralty attorney, so you work with international water law and stuff like that, or you're certified as a specialist in another field approved by the State Bar or American Bar Association, and name of approving organization is clearly identified. So you can say that you're a specialist in something if it's a separate body that's accepted by your state bar organization or the ABA, and they permit it. But typically you can't say I specialize in personal injury unless you actually get the approval. Firm names and letterhead. Trade names are permissible. You must not imply a connection with a government agency, so you can't use the names of 3 lawyers, one being Smith, one being Edison, and one being Christensen, and put just in big bold letters SEC everywhere. You can't imply that you're part of a government organization or government agency. That's just very straightforward. If the offices are in more than one jurisdiction, you must identify any limitations on practice of any lawyers in a particular jurisdiction. So if you're a massive law firm that has offices all over the country, you need to let people know, hey, this lawyer can't do this in this state because they're only bar certified in New York. They can't practice in Tennessee, stuff like that. And you may not use the name of a lawyer holding public office when the lawyer is not actively in practice. So you can't use the name of your state's governor if they're no longer practicing at the law firm. So a lot of governors, senators come from the legal field and they're partners at law firms with their names on the side of the building. But if they're not practicing law while they're in that government position, you can't use their name. And you must only state or imply partnerships when there actually is one. Okay. Last little bit, and then we'll cut it. Bar admission and discipline. To be an applicant to the bar, you shall not make false statements of material fact on your application. You must disclose facts necessary to correct a misapprehension or an issue. These are just the requirements to send in an application for the bar and what that kind of entails. I talked about this a lot at the beginning of the live stream, but we'll quickly cover it now. You must respond to lawful demand for information unless it's protected by other rules. So if the bar association and character and fitness wants certain stuff from you, you need to respond to it unless it's protected some other way. They can deny you admission when the applicant refuses to provide unprivileged answers to questions. So if you refuse to fill out the application, the state bar can refuse to admit you. You cannot exclude people based on their political affiliations or beliefs. You can raise that as a character and fitness concern, but you can't just outright deny somebody for their political affiliation. Then, as once you're bar certified and admitted, you have a duty to report misconduct of other attorneys or judges to the correct body. So, if another lawyer that you know committed a violation, you need to let the bar in your jurisdiction know. And if a judge commits a violation of the judicial rules, you need to let the commission covering judicial hearings and judicial professional responsibility know of that violation. These are just the requirements for it. It doesn't require information otherwise protected. And then you need to report misconduct that raises substantial questions about the offending lawyer's honesty, trustworthiness, fitness to practice law, or if there's criminal activity. Those are what you need to bring forward. Even if the conduct not in legal practice or offending lawyer does not practice law. So if the person isn't practicing anymore, but they're still committing a bar violation, so say somebody's retired, but they're still registered with the bar, you need to bring it forward if they're doing something that's a violation of one of these rules. And if it would reveal client confidences, you need to obtain consent from that particular client. Other than that, there's some info about the MPRE Multi-State Professional Responsibility Exam. This is just the ethics exam that you typically need to take. It's required for admission to the bar in all but 3 states, and this is a big part of character and fitness, being able to pass this. It's based on what we studied today, the laws governing your professional responsibility as a lawyer, and it just asks questions about that. I don't need to take this right away. I need to take this in like a year maybe. So I'm not too focused on this right now. But if people have questions or enough people are curious, I will go ahead and cover this. But yeah, that was everything today. The only thing that I didn't really cover is conflict of interest. And that's because I kind of struggled with that. So I'm going to go and take a quick break and then review that on my own now. I don't want you guys to sit here just listening to me poorly explain conflict of interest. But yeah, like I mentioned a couple of times, go check out my video on how to study and what you should be doing to ace your finals. It relates a lot to these live streams that I've been doing. This is the last study with me stream that I'm going to have for a while because there isn't anything really to study for. My last finals in the morning, so I'm going to be done with this in the morning. I've really enjoyed these streams. It's been a nice way to kill 2 birds with 1 stone and get work done for school and also create some content for you guys. I know that there weren't a ton of viewers during these, but I hope those of you that were here enjoyed this. I really enjoyed it personally. It felt like I was getting more out of my shell and coming more into content creation, and I personally really enjoyed doing it, and I think I'm going to do some more streams in the future, just a break from studying streams because there's nothing to study. So thank you all again for coming to all of these, for all of the comments and questions that you've had. I really do appreciate it, and I appreciate you taking the time to be here with me. For those of you who still have any finals left, best of luck, and I will see you all soon.